Puja is just helping break the news day after day in the industry. So Puja is one of the partners at Troutman Amin, and she is also known as Queenie in the TCPA World Circle, an overall fun person and brilliant attorney. So I'm pleased to have her with me again for the second time this week. Thank you for your time again, Puja. And the famous Aaron Weiss from Florida. Aaron is a regular speaker in our webinars at our summits. Aaron is a partner at Carlton Fields down in Florida, Miami. Correct, Aaron?
Yeah.
And Aaron has been following this case actually for a while. What we're going to be talking about today, and I know we use the generic term Hobbs, and we'll get into why that is. But Aaron, a lot of the cases that have been coming up lately, Aaron's like, "Hey, I'm keeping an eye on this. I'm keeping an eye on this. This is going to happen. I will really want to dissect this with you." And he's really been just focused on this case. And a lot of people in our industry have to be quite honest, because this is one of the most significant decisions I've seen in a very, very long time. And the impact is unknown to an extent, which is very scary. So we'll unpack that. But, as we get started, what I'd like to do is, have Aaron share a story he shared with me the other day. We're going to time travel back to 2013. And Aaron, why don't you kind of give us a little bit of a history or a little kickoff here?
Yeah. So we've all been operating, those of us who have been in the TCPA for a long time, under the general understanding that the FCC creates the regulations and it's the be all and end all. It's the, like Moses coming down with the commandments, from Mount Sinai and so forth. I was thinking about it this morning. I've been doing these cases since 2009, so about a third of my life. You can almost figure out how old I am, or about a very long part of my career. But back in 2013, Puja's partner, Eric Troutman, who some of you may have heard of, and we had a couple cases together in Florida for a client that neither of us currently represent. And a decision came out in a different case from a different federal judge in Florida, not one of the ones we were involved in. It was Judge Bob Scola from down here. And in that case, that was a debt collection case. The case is called Mays. And in Mays, M-A-I-S, Judge Scola found that the debt collector, who the allegation was provided with the plaintiff's phone number just on a credit application, but not with I agree, you could call me, so forth, what we would think of as a consent form. Judge Scola said that did not constitute express consent as defined in the statute to be called. Now, the problem, of course, is that conflicts with what the FCC said about that as early as 1992 and even very explicitly in 2008. And so that was a big deal. And what Judge Scola said is, I'm a district court judge, I'm paraphrasing a bit, Congress and the president have given me my post. I have life tenure. Why am I bound by this FCC to, construe what the law is? I don't think express consent should be found or can be found by just a provision of a phone number without saying you can call me about the debt. So Judge Scola found that he was not bound by the Hobbs Act. Now, there have been, in the Southern District of Florida, where I am, a couple contrary decisions. There had been some case law on this from the Ninth Circuit, the Leffler case, but the issue really hadn't gotten a huge treatment at an appellate level until Mays goes up. So that's 2013. And Mays goes up to the 11th Circuit in 2014 and really becomes the first very detailed, again, there were a couple earlier ones, but Mays was really the first very detailed opinion that subsequently gets cited to over and over, basically saying, as I said, the FCC gets the final word on all of this and we're all bound. So what that has effectively meant for, as long as we've all been doing TCPA cases, with that little blip of the district court Mays case, and a couple very small exceptions, that the FCC's rules have been what guides everybody. as I talked about, for those of you who were at the summit in DC, this is really like fundamentally changing everything. So, we've all been under one system for the last 33 years, and now all of a sudden we're not. So, I brought my props to kind of position everybody. So if you remember, I think what I talked about in April. So for the time that we've been all guided by this system, the TCPA regulations have been our spoon, but now we're in the world of imagine there is no spoon, and that's what we are in. So we don't know right now what is going to guide us. I was thinking, I'm probably dating myself by all these references to 1990s movies. That's from The Matrix, of course. But yeah, I saw there's a new Jurassic Park that's coming out, a movie. I didn't even know they made one after the first one, but the first one came out in 1993, very famous movie where you have Jeff Goldblum's character has the chaos theory, and he talks about what happens when you just have total chaos and we don't know what's going to happen. I kind of think like I woke up on Thursday morning, or kind of hit me out Thursday or Friday morning, I guess. Thursday was a holiday. We're now kind of in the chaos theory land of what happens with the TCPA, and it will kind of take a little while for all this to shake out. But Puja can tell us why, or maybe that I'm wrong.
Yeah, so and I think that that's a good idea. And I think that, really looking at that, Puja, what is hops? What exactly does that mean, and how does that apply to this, Mays case, and just broadly to us as a whole when it comes to interpretation of the FCC's TCPA?
Yeah, a funny story, Isaac. I think last week when the news broke, the SCOTUS ruling, one of my colleagues, the Dame, Tori, had asked me, she's like, what does Hobbs Act even stand for? And interesting, I actually had to look it up. Apparently, it was named after a congressman. Leaving that aside, how the Hobbs Act applies to the TCPA in particular. So the Hobbs Act is a federal law, and it governs essentially the judicial review of admin agency decisions such as the FCC, right? And previously, right, the courts had to faithfully apply any decisions by the FCC as binding. In order to, challenge any of those orders, you had to take it to the appellate level, right? You could not, after the Hobbs Act was implemented, you can no longer fight those on the trial court level. So as, Aaron had just outlined for you, during the Mays time period, right, the Mays decision reversed a district court's ruling that refused to apply the FCC's express consent exemption. Now that is no longer the case, right? Which Aaron will tell you here in a little bit. But, generally just think of it as a federal law that forced district courts essentially to look at FCC declaratory rulings as gospel.
Okay, I think that really simplifies it quite a bit. So there's a contentious issue in the TCPA. The FCC sits down, they look at it, and they say, this is what it means. I mean, it almost sounds similar to what the Supreme Court does in a lot of cases, where they say, based on the Constitution, this is what is allowed, this is what's not allowed. I mean, it's a similar thing, just focusing on that bill, correct?
Correct. And
that act.
The intent there was to indicate that the FCC's rulings on vague words and phrases within the actual statute of the TCPA were binding on the district court, right? The way folks viewed it was the FCC is assisting courts on how to interpret the TCPA properly.
And for those of you who have been in the industry for a long time, we spent a decade talking about a comma, and since the comma isn't there in the statute, this is what an ATDS is versus this is what it is not. Puja actually wrote I think it was your article actually, just a couple of days ago for TCPA World that talked about the Texas law. I know you guys have a webinar coming up on that, where you basically side by side compared Texas's definition of an ATDS to the TCPA's, and something like that comma or the placement of almost the exact same words but in a different order gives it theoretically a very different meaning. So, there is a lot of ambiguity, there's a lot of vagueness, a lot of just general lack of clarity in pieces like the TCPA, because as Puja's partner will commonly tell you, you should have nobody but attorneys writing the law. On the one hand, I agree with that, but on the other hand, you've got attorneys who don't understand anything about technology writing these rules or about the industry that they're regulating. And so it's, they're going to be leaving a lot of things out because it makes sense to them, but it not to other people. So, fast forwarding, we've had this clarity. Okay, so that's pretty straightforward. FCC can issue declaratory rulings, or an agency in general, to say this is what it means. Great. So then let's fast forward down to McLaughlin, Aaron. What happened there, and how does that relate to Hobbs?
Sure. So McLaughlin arose once in a while. We still have fax cases. I think I like to joke I get about one a year, kind of a steady flow. Like once a year, I get somebody that calls me with a fax case. I started out doing fax cases. For those old timers on our call, I took Caroline Abraham and Brian Lance's depositions, so that kind of dates me. But there still are fax cases, and there was this case, McLaughlin versus McKesson. By the way, that case I think goes back to filed in 2009 or something. It's an extremely old case.
It's old.
So in the fax space, there's kind of been two issues that have come up, and actually two of them went to the Supreme Court. But in the fax case, the specific issue in McLaughlin has to do with essentially what we think of as like computer programs that convert faxes to emails. And the statute, I guess, when the statute came about in 91, I suspect those programs weren't commonly used, if used at all. Now I guess they are. I actually have one of those. But in 2019 or so, the FCC issued a declaratory ruling. And, Puja and I are going to talk about whether that McLaughlin coming up in the context of the declaratory ruling, as opposed to a notice of proposed rulemaking and a formal rulemaking resulting in rules published in the CFR makes a difference. But in any event, just talking about specifically what happened in McLaughlin, in that declaratory ruling, it's called the AmeriFactors ruling. AmeriFactors was the party who petitioned the FCC for a declaratory ruling. The FCC said these computer faxes don't count as faxes covered by the statute. I'm paraphrasing, but that's the big takeaway. So in the case itself, the plaintiff, it's very difficult to certify a class for a plaintiff if computer faxes not counting as faxes, it is what the law says, because it's, as far as I would say, it's impossible to determine if any given fax machine is a so-called computer fax versus a traditional fax. Let's kind of go with that. So the plaintiff's side of the ledger on this particular issue, by the way, and this is what we can talk about, that a lot of these issues where the FCC rules are ones that objectively would fit. Do you have me? Yeah. So a lot of these issues would objectively favor defendants. This particular one objectively favor defendants, but some of them objectively favor plaintiffs. So it's not like the Hobbs Act per se favored plaintiffs versus defendants in these cases. But in that particular case, the defendant liked the ruling, the plaintiff didn't, and the plaintiff went all the way up to the Supreme Court. And what the court said in the 6-3 decision issued by written by Justice Kavanaugh is the court is, a district court is not bound by these FCC determinations, that the going to the Court of Appeals after the ruling is issued within that 60-day period, that is something that a party can do and make a pre-enforcement challenge. That's what happened in the IMC case that we talked about a few months ago. But what Justice Kavanaugh said is you don't have to do that. That's an option. But if you don't do that, you could still challenge the rule in what is called a private enforcement action, is the fancy term the Supreme Court calls for all of the cases that, a private plaintiff versus private defendant. So that's kind of the short of it. It was basically the decision ultimately tracked very closely Justice Kavanaugh's concurring opinion in a case called PDR, which was the last time that this issue was before the Supreme Court. What was interesting in that case, that it was also a fax case, but that one had to do with the form of consent that had to be on a fax. And that also comes from an FCC rule. But interestingly enough, in that case, the interests were flipped. So in PDR, the defendant was the one challenging the FCC rule. And I thought it was, the height of where you sit goes by where you stand. If you look at the amicus curiae, the people who filed briefs supporting one side or another in McLaughlin, kind of was exactly the opposite of versus McKesson, which to me is an extremely bad look. It's a shame that the industry interests couldn't get together and come up with a unified position on how they want to land this issue. So that's my soapboxing for the day.
No, it's interesting because you take, this news, and it wasn't too long ago that we're all talking about Chevron and what happened there. So, Puja, how would you differentiate the impact of this decision or what this impact means versus, the decision that was made in Chevron?
Well, I think the biggest thing is after Chevron, right, Isaac, we thought we had at least Hobbs Act to rely on and to still rely on dozens and dozens of orders, right, addressing key proponents of the TCPA, such as fax, right, auto dialer, call party, express consent, right, reassigned number, all those phrases, we at least had some guidance when relying on Hobbs Act. And now with Hobbs Act, disappearing, I mean, it's going to have a huge, huge impact, right? That are going to be somewhat fascinating and somewhat terrifying, right? Plaintiffs' attorneys now with Hobbs gone and with Chevron deference gone, now literally for plaintiffs' attorneys are going to be forum shopping. They're going to be looking for new favorable laws in areas where the FCC declaratory rulings actually provided the defense more favorable law, right? And required courts to abide by some of these declaratory rulings that I know we'll get into a little the different pieces that are going to be impacted when you're litigating TCPA cases, but I mean, huge ramifications, right? I mean, some of them might be good, right? Depending on how quickly good defense lawyers can get in there and make good law. But, there's going to be some negative impacts as well, because we are going to have to be forced now to apply certain definitions that were more favored on the defense side.
And I think this is where it's important to point out to everybody that, when Chevron happened, there was a lot of fear. We started seeing a lot more interpretation at the court level. And there's still some stuff, as Pooja said, it's like, well, we still have Chevron, so we still have the declaratory rulings. We have things like that to rely on. But we have seen, for the most part, I think the judges are coming to the right conclusion, even if the logic behind it may be a little bit different than what we're used to seeing in some of the logic that got us that same endpoint eventually. I haven't seen it as a huge blow up yet. But we've also seen a lot of things where you'll see one court issue a ruling and then you'll see the Supreme Court quickly overturn it. And a lot of that just has to do with, who's in charge of the decision. So, when you start taking this at a lower level now, if there is even more freedom for the courts to make their own decision, there's a greater chance that they're going to decide differently than, say, the FCC decided a few years ago. And Aaron was talking about something that I think is very interesting about all this. The industry and, having been involved in industry trade groups over the years, I've seen a lot of this. I participated in a lot of this where it's very unclear what's going on. You petition the FCC and the FCC may say, you know what, you're right. That isn't very clear. Let's discuss it or let's issue some clarification on it. And even if you don't like the rule, at least now you know clearly what the rule is.
And Isaac, to that point, right, like very, very important takeaway, because the rationale used in McKesson versus PDR resources, very different, right? There, the court implied, there was a distinction between legislative acts and declaratory acts, right? The dichotomy still may hold true in like future cases, but it doesn't seem to matter in the McKesson rationale, right? The words of the Hobbs Act itself provided the only analytical tool for us to rely on. So, with Chevron going away, there was a certain avenue that we had, right? based off of how the ruling was worded, but now with Hobbs Act, completely different world, as you correctly mentioned.
Let me kind of give you my thoughts on that. So I think that if Justice Breyer's rumination on legislative versus interpretive rule. So PDR, as Puja mentioned, that there was a majority opinion. There were 5 justices who joined the majority opinion in PDR. There were 4 on the concurring. They called it a concurrence, really wasn't. But I think what's notable, and I went back and I pulled them up side by side. I do not think that because Justice Breyer didn't affirmatively say that it matters if it's legislative or interpretive. He speculated that was a prefatory question that the Court of Appeals first had to answer before the Supreme Court would give an answer. And Justice Kavanaugh's opinion in McLaughlin from Friday just, drives right past that. I think he gets a very short shrift. And, so I don't think that is going to be an available argument. I don't think that somebody can say, well, but 5 justices in PDR said this interpretive versus legislative may matter. That's just my take on it. Others may have a different thought. So that's that. Isaac, I did want to add something about Chevron because I think it's very important. In the Loper-Bright decision, which is the decision from last year that overruled Chevron, 40 years of Chevron, the one thing that the court said that Chief Justice Roberts' majority opinion said is there is something called what stare decisis. That means that the decisions that have been issued in the intervening 40 years from Chevron to Loper-Bright will still count. In other words, it's not completely a blank slate. Now, there's a caveat to that. 3 days after Chevron, the Supreme Court had a case called Corner Post that basically said that if you weren't around when the regulation you're going to challenge was issued, you can still challenge it. Leave that aside. What is critical, I think, in McLaughlin is there is no such reservation. And if you think about it's a different. You could understand the rationale if you accept the rationale of McLaughlin, where in PDR, Justice Kavanaugh said, there was Chevron deference and, that's now questioned. 5 years later, they overruled it. But what he described in PDR, he called it Hobbs Act abrogation. So if you think about coming from that basis where now the majority of the Supreme Court had a real problem of saying that the courts can't even decide what something is, you can understand why on McLaughlin they didn't include the same stare decisis for whatever's been decided before. We're not going to directly touch that. So I think that's a big thing because that's a difference in all these so-called Loper-Bright challenges. You still have to get over that stare decisis issue. And there's a couple cases that have talked about it. I don't think that's going to really be an argument that's going to fly in these post-McLaughlin challenges.
And Puja, do you agree with that? Because that was on my list of things. Is how is that going to be viewed moving forward?
I don't know, Isaac. All right. Usually, I have an affirmative response to this. I know, Aaron and I had exchanged some emails along with Eric. But the short answer is I don't know. I don't know how folks are going to be able to challenge the CFR provisions, or I know, Aaron, you think that the CFR can essentially just go away. I completely.
But this is the concept of challenging CFR provisions as being like, even before Loper-Bright, people would say that I'm challenging so-and-so, final rule of the DOL or, whatever in a private case. And you would have the Chevron step 1 and step 2 analysis. And now post Loper-Bright, it's kind of the same analysis. That's different from a 706 challenge. So Loper-Bright itself, right? So Loper-Bright was Loper-Bright versus Raimundo, who at the time was the Secretary of Commerce. So that the Loper-Bright were the people that owned the fishing boat and didn't want to have to pay for the inspector. So they sued filed an APA action against the Department of Commerce. But if it's a statute where, that has a private enforcement mechanism, where there's some, private right of action or accessory, sometimes like there's, sometimes you could have different state or federal statutes that could arise from some provision of the CFR. That's long been fair game that you could challenge those in private enforcement actions. You just, before Loper Bright, you had a higher bar with Chevron step 1 and 2. But others may disagree, and I know some folks in California who may have some other thoughts, but I think there's a pretty fairly well established body of law on that, but we'll see.
But to be clear, you're talking about the rules, not the rules where Congress explicitly told the FCC to implement those rules, right? Because courts aren't going to set aside those rules, because then you have separation of powers issues, right? So if the Congress told the FCC, you must do this, I don't think the courts are going to set that aside. But
I'm
please.
sure that. So read IMC. So IMC says, FCC, go out and issue your rule, right? So if you find that the rule is exceeded the delegated authority, you still have the argument available. So that you'll have people will say one way or another. Again, I think you're going to have defendants and plaintiffs making it's whatever the cause of action is, and we should start to, we can talk about some of the specific ones. But wherever people sit, they will say that the FCC issued what so and so rule, that there was delegated authority to go issue rules for whatever, and delegated authority to go issue rules for consent, and in the one-to-one rule, the 11th Circuit in IMC. Now that was a direct Hobbs Act challenge. But yeah, the Congress gave delegated power, but the ultimate adjudication was the FCC exceeded that delegated authority.
No, and that's kind of where I wanted to go next. And real quick, just as a reminder for everybody, I've looked through the attendee list a couple of times on here, and I see that we've got a good representation from attorneys on here, but we've got a lot of people who are more industry leaders. So if some of this is way over your head, we're going to start bringing it a little bit down to earth now. But it's important that you don't just take these little webinars, an hour a month or 2 hours a month to get your information. Make sure you're keeping these conversations going on. We have an annual compliance summit every December. We'll be releasing some info on that. A Law Conference of Champions hosted by Troutman Amin is going to be in just a couple weeks in July. And you'll have the entire Troutman Amin team there. You're going to have a lot of great people there you can work with and discuss this more. So please get involved, get out there. We'll throw a link out there in the chat even for you guys for the upcoming Law Conference of Champions. Highly recommend it because please tune into our webinars, but you're going to get even more if you have follow-ups after these. So let's take it, back and let's, building on that IMC, one of the challenges in the IMC case was, of course, that there was an overstepping of what the FCC had the power to do. And this has been a discussion that's come up quite a few times because there has been, okay, well, what authority was delegated to the different agencies, and you can even talk about the FTC and some of the stuff that could happen there, but it's, what power do they have to make modifications? Can they just add any rule to the TCPA, or does that require an act of Congress? And that was, I think, a big part of what the IMC ruling was about, versus, what areas do they specifically have authority to make rules around? So, could, an open question, maybe Puja, if you want to start, but anybody jump in. Where do you think this would have the first big impact in the TCPA? What do you think somebody could, plaintiff's attorney can look at the TCPA tomorrow and say, even going to the prior express consent or prior express written consent, look at one of those and say, hey, this doesn't mean prior express consent, or prior express consent isn't exactly a provision that, they had the authority to find. I mean, where do we see some of that impact? What are some of the specific rules that we take as gospel today that we think are at the very least going to be questioned tomorrow?
Yeah, I'll list out the few areas, Isaac, that I think are going to be challenged, right, by both plaintiffs' attorneys and defense attorneys. So just level setting real quick, right? The court's rationale looked at the language of the Hobbs Act, and they determined that the structure of the act demonstrated that it was only to prevent the district courts from taking action, right, across the country respecting to those FCC rules, which I'll get to in here a bit. But the question is, right, like, is merely refusing to apply an FCC rule, right? Is that's not setting aside a rule or order, right? That is what's going to be challenged repeatedly in courts. As to the CFR provisions, those that were crafted without the express authorization, right? Those are likely going to be subject to court scrutiny now. And I think examples, number one, right, piggybacking off our webinar on Monday, are going to be the quiet hour restrictions. I think the express written consent definition, right? Because if you look at, how it's written, right, the courts have interpreted, as we know, many rulings have gone out what express written consent means. How about text messages equals calls, right? That one I certainly think is going to be challenged, primarily probably on the defense side. And plaintiffs' attorneys are going to really want to fight for that one in particular. And then lastly, I think the cell phones as residential numbers for do not call purposes is another one that'll get challenged as well. I don't know if you think, I think Aaron thinks they're all going to be challenged, but those are the ones that I think, the four that I'm looking at in particular.
Yeah, I think those, and I'll offer a supplement on the express consent to kind of preview what I said with Maze. If I was running a call center who did debt collection calls,
Correct.
I would be quaking in my boots right now if I was calling people who don't have what we would think of as a written consent.
I agree with you, Aaron. I think that's gonna be one of the biggest challenges is for the debt collection industry, who traditionally relied on a lesser standard of consent in order to make.
It's a huge paradigm shift because what in the last 10 years, I don't know. I mean, debt collection. I won't name specific plaintiffs' lawyers, but most of us know who they are. It's wrong number debt collection cases, and there have been a ton of them. There have been a few, and they've been very big numbers. But that's all you have because single plaintiff ones, okay, whatever. I've had a few of those over the years, but these debt collection calls, oh man, you're going to have a lot of those come up, and the plaintiff lawyers are going to find the right judge on that, and somebody to bite on what Judge Schloss said, that just listing your number on a credit card application is not sufficient consent. But then you have the flip side of as Puja said, the express written consent. Now let me blow your mind here. Prior express invitation or permission, that was a rule. Now you could stipulate for the moment, although I may beg to ultimately disagree. But if you stipulate for a moment that the 2003 rulemaking, which essentially leads to the national do not call list, was a rulemaking that made available a private cause of action pursuant to a properly delegated grant of authority. You could. There's an interesting argument that it wasn't, but assume that it was, and that issue was really separate from the McLaughlin issue. Here's what's interesting. That formulation that comes from the 2003 order, that's a delegated rulemaking, from Congress, says basically, it's a little wonky. The FCC had started that rulemaking and it got a little complicated, but Congress passed something called the Implementation Act, where they said, go ahead and continue that rulemaking. So let's assume that was a congressionally approved rulemaking. And that's where they come up with prior express invitation of permission, which most people think is the same functionally as prior express written consent. I mean, I've never seen a case that says prior express invitation of permission in prior express written consent are different. And that's pretty much, I think, I don't know where the distinction would lie. What's interesting is one could argue comes from a congressionally delegated rulemaking. Whereas the addition of prior express written is not in the statute. The 11th Circuit all but said in IMC that was, the FCC just adding something that wasn't there, and it got ahead of itself. So you could see a situation where you would need prior express written invitation of permission for do not call type claims. but not for, pre-recordeds and auto dialers to the extent those are still in play. So that's just something that occurred to me.
Yeah, and I
So
think one of the, oh, sorry, go ahead, Isaac.
no, go ahead, Puja.
That's a huge compliance takeaway, right? Express consent probably just means express consent now, right? You can't assume that numbers provided by an individual is going to be consent for informational calls using regulated technology now, right? It's really interesting because, as Aaron said, the do not call rules, right? If you read the TCPA, the TCPA doesn't say you can't call a number on the DNC, and if you do, then the consumer has a prior right of action. It says that if you violate the FCC's rules around the implementation of the DNC, then you can bring a lawsuit, right? So what does that mean? Does it mean that the court has to apply the FCC going forward?
Yeah, that vagueness is where I think a lot of people just try to avoid the whole court cases altogether, and that's where things like, there's some of these that are easy, like the collections and the wrong number things. That's a huge thing. I mean, that goes all the way back to Melody Snopes, and there probably even people were trying it before that, but just heavily targeting phone numbers that have been changed hands, maybe even recently changed hands. You get into third-party debt collection where somebody's going out and buying a bunch of debt, and they're trying to reach out to these people who now have been delinquent for 6, 12 months. We see, oh gosh, I don't know, 300 plus million phone numbers returned every single year. So when you're in a debt collection environment, you're going to see an even higher likelihood from what we've experienced of those return numbers, because they haven't just defaulted on one bill, they've defaulted on several bills, one of them being their cell phone. So there are very easy ways to find out if a phone number has changed hands. At dnc.com, we do have a service for that. So reach out to us, click that chat with an expert link. We can help you with that. And likewise, we've got a litigator scrub. So that's going to be a big part of this, is how this impacts the plaintiff's bar. If you just want to avoid the plaintiff's bar altogether, use that product. It's very well priced, and it will, if it weeds out just one litigator a month, usually it tends to pay for itself. And so to that end, looking at how we could envision this is one of the questions from the audience here, is how this will impact professional plaintiffs. I think, on the one hand, we're thinking, okay, what are they going to try to challenge next that everybody's been relying on? But is there a silver lining in that maybe this is going to take some teeth out of it? And this is all speculation, but I think, Puja, you brought up SMS. That's a great example. When you and I were talking the other day, we're talking about quiet hour violations, and these suits are typically about SMS, and there is a lot of discussion. Well, it's not the same thing as a phone call. So, how will this impact the plaintiff's bar?
Well, to start, I think there's going to be a ton of forum shopping, right? And for those, non-attorneys on the webinar here today, that essentially means, right, plaintiffs are going to be very active, and they're going to choose specifically where they decide to bring a lawsuit, right? So you can imagine the states that are extremely liberal, that is where plaintiffs' attorneys are probably going to want to go first. The ones where, I can imagine like the Ninth Circuit, I think the plaintiffs' attorneys are going to be very eager to get in there first to make good law. So what does that mean, right? That means that they're more likely to want to litigate in those states as opposed to easy settlements. You go to the 11th Circuit, especially after IMC, right, out in Florida, I suspect plaintiffs' attorneys are going to still file the lawsuits, but they're going to expect, or they're going to hope for quicker settlements on the onset, right? So I think that patchwork that we were used to during the ATBS timeframe is going to come back, and we're going to have to really, really track the court's decisions as we navigate, the different rulings that are going to come about. So I think, both defense side and the plaintiff side are going to be very strategic in their litigation strategy, as opposed to just kind of, plaintiff attorneys filing everywhere and seeing what sticks, which has kind of been the case in the last 2-3 years, right? Plaintiff attorneys have kind of sticky everywhere. I think that'll change with a more focus on the liberal states.
Now, what about declaratory rulings? Obviously, I think it's pretty clear where this decision affects those, but rulemaking proceedings. So there is, the ability for them to go through a rulemaking process. There's a notice of proposed rulemaking that comes out, or NPRM, and they solicit, insight, input opinion, whatever, from the industry, from anybody affected, on either side. And it's a big process, and it's an interesting process because you really get a peek into when they issue their final decision, why they made their decision, what they're looking at, how they're thinking. Are NPRMs or any sort of rulemaking process also dead and any historical rollback, or do we think that that part is still allowed? What do we think the impact is there?
I think they're dead. Aaron, you might disagree. I think, I think the avenue to bring them will be available, but with the current state of the SEC, I think they won't be regarded as much as they have been regarded in the past.
Let's say check back in 3.5 years, depending in November 28th, but Puja and Eric are closer to the FCC, but I mean, that's kind of more philosophically across the government. I think we're in executive orders lands, and I don't think you're gonna start to see a ton of agency action on a lot of stuff. I think that's more of an across the government thing. So, but we'll see. You never know. I had a question though. Puja, I saw from one of your colleagues, you guys did a very good job about posting kind of different aspects of the statute and landscape that may be affected. I think Blake did something about ATDS. I was a little curious. I don't know if there's much that will change from this on ATDS, but what did you think?
I'll be honest, Blake, I apologize. I have not read his article yet, so I don't know what his thoughts are. But I think from an ATDS piece, I think courts have, for the most part, already been using their decision-making authority to interpret the definition of ATDS. So I agree with you on that, Aaron. I think it will remain the same, especially after Facebook. I don't expect to see much movement on that end.
Yeah, I mean,
but I do think there's going to be more movement on the state level, right? I think plaintiffs' attorneys are going to start leveraging more of the state laws and the nuances with the state definitions of ATDS, similar to like that new Texas rule that came out. So I think that's what's going to happen is they're going to marry the TCPA action along with the state regulatory actions, which they already do, but I think they're going to focus more on the dialer piece more so than the state DNC pieces.
Yeah, and I've got one for you though. How's this? So Puja talked about the issue of whether or not cell phones or mobile phones or commercial mobile radio service are covered by the 227C. This is the National Do Not Call and Internal Do Not Call in shorthand. So I think it's a very good argument now that cell phones are not going to be covered. Let's see what happens, but I think there's a good argument there, notwithstanding what Josh Catcho got a judge in New York to say. So assume that comes out. There's a number of state statutes that give rise to a do not call private right of action by your number being on the do not call list. Doesn't say residential number. It says you have a right of action under so-and-so state if your telephone number, and I don't want to give up the goose here, is on the national do not call list. What does that mean? Do you have the same residential versus business number for that state law claim, even if ultimately the fact the national do not call list and the right to have the claim only applies to so-called residential and old-fashioned landlines? So that's an interesting one that's bothered me.
Well, the use of the word line, and this is where, some of it may come down to the judge and their approach to, how they interpret law, but the word line is a physical cable, something I look, like this. And for those of us that, have some gray in our beard, we remember when that's how everybody talked over the phone. And, now, I look at my cell phone and technically they're SIM cards or eSIMs. So, can it get to that level would be interesting. I also think about things, and this was even a question that came up from the audience. We were talking about checking for number reassignment in the past. one of the big benefits of the federally authorized reassignment database, or supposed benefits, is the safe harbor provision for potentially getting bad data back from the R&D. Now, I am not aware of anybody actually trying to stand on this leg, so I don't know how real it really is. But, what about something like that? Or what about, any sort of, windows on EBR, or the 18-month or the 90-day period, or any of that? Does any of that go away, or is any of that challengeable in this, or do we think that's set in stone?
Well, EBR is incorporated into the statute by direct. That's like the one part of the statute that directly takes an FCC rulemaking and specifically says, after the FCC rulemaking goes back and says, that's the definition we want, the one that the FCC says. So EBR, I don't think you're going to have much of a challenge on that. What the others? It depends.
I think this is why you're going to have to come to the summit in Florida. I'm sure Aaron, Puja, and many other brilliant minds are going to be there to kind of say, well, this is what we've seen so far, and based on this, we can better future cast what's going to happen in the next 6 months. But to what Aaron said earlier too, I think that it might be a few years before we really have a good handle on things.
Yeah, and as I always like to say, Isaac, every time I talk at one of your events, either virtually or in person, there's the fundamental difference between TCPA litigation and TCPA compliance. If you think that all these good ideas you hear from all these clever lawyers about how you could defend a TCPA action is a good compliance strategy, good luck, or as they say, good night and good luck. I mean, that's not a good idea. These are a lot of things we're talking about from like kind of the defense side. Things are interesting arguments that people can make. But if for proactively, I'm kind of loosening the belt. If I was running in charge of an internal person running a compliance program, I wouldn't loosen the belt much. However, some of the things that we talked about, there are a few defensive things that I think you may actually probably want to think about. One of them I mentioned, of course, if you happen to be in the debt collection industry, I would, radically reevaluate or evaluate your practices top down, like, the second we finish the call. That's important. If you're faxing, what you should do is take the fax machine and maybe go outside to your garbage bin. Because whatever, but I guess there are some industries that think faxing is still a good idea. And if you were in the industry and said, all right, I've got no risk anymore for faxes because I read Amerifactors and the SCOMA chiropractic, I guess, was the first case that said you can't get a class certified because of e-faxes. Well, I guess you can't count on that, but again, listen, if you're still faxing like in 2025 as your marketing strategy, you've got bigger problems. I can't help you.
We're going to link to that. I know we were talking earlier about Blake's article. There's TCPA World. If you don't subscribe, I highly recommend it. We're going to put that article we're talking about Blake's ATDS thing, which Puja has yet to read. But I'm sure she'll get to it. I personally do read everything that's published by TCPA, maybe not the exact day, but within a week, certainly. So we'll put that out there for you. Puja had a great article a couple days ago about Texas. I highly recommend everybody looks at. Looking at, TCPA World, some of the other resources, the Troutman Amin 9, there was the 15, and then with 1-to-1 going away, we kind of rolled back to that 9. But talking about consent language and talking about collections, one of the questions that was asked by the audience was, when it comes to first-party collections, everything is still okay, right? If they've got their contracts giving them permission to phone, market, text, etc., use pre-recorded voice, is that still okay, or is this more to Aaron's point? You should even be reviewing all of your consent language to make sure it's even more bulletproof.
I think if you have the Troutman 9, you're safe, right? Making sure that you have all requirements of the prior express written consent. I think actually in some jurisdictions, right, with the courts that are looking at layouts and disclosures and hyperlinks and, looking at other guidances, I think it's going to be even easier to obtain consent, dare I say, in certain jurisdictions, right? But obviously, a lot of folks are marketing to all 50 states, right? So right now, I think the gold standard is still Troutman 9 if you're looking to obtain consent for marketing purposes.
Okay, and then for people who are looking at, again, I'm doing a lot of these calls to people. Does this relax any consent standards? So I've got one person asking about, if they're using an ATDS and not using pre-recorded messages, do they need that consent? And arguably, if the person's not on the do not call list, then that makes it a lot easier. But let's say they're on the do not call list, but they still want to do a service, not solicitation, but a service type call. Do they have a little bit more freedom to do that now, or do they have less freedom? Is that unaffected? And again, all speculation here.
Look, right now, there's no freedom to do anything, right? The freedom is up to the courts in order for them to be able to interpret the law. They have not done that, right? The biggest takeaway, I think, for now, right? I'm sure Isaac and I will have another webinar in 6 months to give you an update on the case law. There's more uncertainty, right? But there are bullet points to defend in litigation. So folks who are currently in litigation, those are the people who want to strategize with their TCPA lawyers, file appropriate motions to dismiss. Definitely don't settle the quiet hour provisions, in my opinion, or not legal advice, right? So from a litigation perspective, we have bullet points, right? We got the armor for now. But it's going to be really interesting to see what courts do in litigation, and we're going to have fractures all over the place, right? I can imagine a heat map coming your way on tcpaworld.com, so be ready for that. But from a compliance perspective, please just continue to stay buttoned up, right? Get, as Aaron said, if anything, get more buttoned up if you're in certain verticals, but do not look at this as a decision to kind of loosen your compliance standards. Quite the opposite until we have more actual law in place.
So we've got about 4 minutes left, and I know there's a few Q&As that we're not going to be able to get to. Please make sure that you are following up after this. All of our contact information is here, so please reach out to any one of us. We'd all welcome more conversation on this. I'm going to give you each minute and a half or so for closing thoughts. So Aaron, you first, and then we'll let Puja have the last word here.
Takeaway on what you should do now, I was going to say what she said. Puja, summed it up exactly right. Don't relax anything. And the only, thing is, in certain areas, you may actually have to change your practice. Here's what my biggest takeaway. It's kind of an unusual one, but I've seen a couple people be burned by this. And I know Eric wrote about this. You know what, to me, the biggest risk for TCPA compliance is right now? AI. Because Google AI or whatever AIs are spitting out, nonsense. And I have this concern that what's going to happen is, you're going to have a lot of people on, TCPA world, whatever, my Law 360 articles that they have me do and whatever, people will generate things and people talking about litigation strategies. Google AI does not understand the difference between litigation strategies and compliance, and people are going to do a Google thing, get the AI thing and think that's their compliance plan. And if you do that, you deserve to be sued.
Yep, you do not deserve to win. Agree with you, Aaron. It's amazing. I saw the czar playing around with AI the other day and asking it questions. He actually got in a fight with AI. It was quite funny because it was so wrong, right? It always appears to be right, but consult good lawyers. My takeaway, Isaac, is I'm going to do a shameless plug. Attend law conferences of champions because, dare I tell you, the czar is staying quiet. If you notice, he is staying quiet on this Hobbs Act ruling, because the first time he'll be speaking about it on stage will be law conferences of champion. And I know I'm eager to see that because there's so much more interpretations and opinions that are going to come out, and his in particular, I'm really looking forward to it. So if you haven't already registered, I encourage you to register. And then I'm sure Isaac and I will have more webinars as case law continues to come out. So stay tuned.
Yeah, Law Conference of Champions. This is the 3rd year now for that conference. This will be my 3rd time going. It is better and better every time. Well, so far, the 2. So number 3, I'm sure, is going to be better. It's a bigger lineup. There's a lot of people already signed up. I think there's still a few tickets left. So I would love to have time to sit down and talk with any of you out there in the audience in person at the event. I know I'm speaking for Puja and her team when say they would welcome the same thing. So please make sure you're getting out there. Please make sure you're following our YouTube channel, subscribe to our LinkedIn. We're going to have a new newsletter program starting soon. We'll be announcing some sneak previews and things like our AI regulations we're adding to our compliance guide in the next month. And then, please connect with Aaron, connect with Puja, follow them on LinkedIn. Make sure you're going to their websites as well and following them. This is the only way you're going to get the absolute latest information and be just up to the date as much as possible on developments. Again, something like this shows that we don't necessarily have clear rules of engagement. So the best we could do right now is watch the industry, react, and do everything you can to keep yourself in a defendable position. So Aaron and Puja, as always, thank you for your time. I value your partnership. I value your friendship, and I look forward to seeing you in person very soon.
Thanks, guys. Take care.
Have a great day, everybody.
Bye.
Bye-bye.